All right, so we're diving into something today that I think a lot of people have probably experienced.
Yeah.
Dealing with tricky landlord situations.
Yeah, for sure.
You know, you feel like you're walking on eggshells and you're not really sure what your rights are as a tenant.
Absolutely.
That's what we're going to be unpacking today.
It's a good one.
We've got a whole stack of sources about tenant rights and eviction laws right here in California.
Mm-hmm.
And we're really focusing on how you can protect yourself.
Right.
Especially if you're dealing with a difficult landlord.
Absolutely.
Renting can be stressful enough as it is.
Oh, for sure.
Without feeling like you're totally in the dark, right?
Yeah. Feeling secure in your home is essential. And it's empowering to know that California law actually offers substantial protections for tenants.
Yeah.
We're talking about a range of issues that can cause major disruption.
Yeah.
From dealing with uninhabitable living conditions to facing potential wrongful eviction.
We've all heard those horror stories, right? About landlords who seem to think that they hold all the cards. But our sources make it crystal clear.
Yep.
Tenants do have rights.
Absolutely.
It's not a landlord always wins situation.
Yeah, you're not powerless.
Yeah. And for example, one of our sources talks about landlords using bullying tactics, which is a good reminder that being informed is your best defense.
Oh, that's a great point.
Right.
Understanding your rights can make all the difference in those situations.
Yeah.
And speaking of landlords who push the limits, let's talk about a term that often makes tenants cringe.
Okay.
Slumlord.
Oh, yeah.
That's
everyone hates a slumlord.
Yeah.
So picture this, a landlord who's basically the villain in a rental horror movie.
That's it.
That's your classic slumlord.
That's your classic slumlord.
But how do we actually define that in real world terms?
Well, our sources paint a pretty vivid picture.
Okay.
Imagine this unsafe electrical wiring that could be a fire hazard.
Oh my God.
Ignoring those urgent repair requests, and then, get this, blaming you, the tenant, for the damage.
Wild.
That's classic slumlord behavior.
So if I'm dealing with something like that, it sounds like it's time to get serious about legal help.
Yeah, absolutely.
Right. It's time to...
What are the red flags that scream lawyers up?
Let's lay it out like a checklist.
Okay, I like it.
First, if your landlord consistently ignores repair requests, especially those that impact your safety and health, that's a major warning sign.
Okay.
Think a leaky roof that's causing mold.
Oh, yeah?
Or a broken heater in the dead of winter.
What about a landlord who just totally disregards my privacy, like barging in unannounced or refusing to give me proper notice?
No-nos.
Before entering?
Absolutely, your right to privacy in your own home is paramount.
Makes sense.
Another red flag is when you're signing a lease.
Okay.
And the terms are confusing or seem downright unfair, especially when you're moving in or out.
Those lease agreements can be tricky, and you don't want to get caught off guard.
So if I understand correctly, having a lawyer actually look over the lease before I sign can save me from a lot of headaches.
Exactly.
Potentially down the road.
A lawyer can help you decipher that legal jargon and ensure you understand your rights and obligations under the agreement.
It's so easy to feel intimidated in these situations.
Oh, yeah.
You know, you feel like you're David going up against Goliath, but knowing that you actually have legal options that can really shift the power dynamic.
Absolutely. And let's add a couple more points to our checklist.
Okay.
If there are any disputes about rent or that security deposit,
classic.
Those are classic scenarios where having legal counsel on your side can make all the difference.
Yeah.
And of course, if you ever feel harassed or pressured by your landlord, don't hesitate to seek legal advice.
Okay. So let's say things have escalated.
Yeah.
And the E word is on the table.
Uh-oh.
Eviction. What are the key things we need to know about how that process works here in California?
It's crucial to remember that eviction is a very specific legal process with distinct steps that have to be followed.
Okay.
And here's something that might surprise you.
Okay.
There are several defenses against eviction in California that tenants should be aware of.
So it's not always a slam dunk.
No. It's
for the landlord.
It's not always straightforward.
What kind of defenses are we talking about?
Well, you might be surprised to learn that landlords sometimes make mistakes on those eviction notices.
Okay.
And get this.
Yeah.
Even a small error like the wrong date or some missing information.
Oh, wow.
Could be enough to challenge the entire eviction.
Interesting.
It's like a legal loophole.
Yeah.
So those little details matter.
Are there other examples of common defenses against eviction?
One that comes up frequently is landlord retaliation.
Okay.
Imagine this. You request a necessary repair, like fixing that leaky roof, and instead of taking care of it, your landlord tries to evict you.
Wow.
So it's like they're punishing you for simply exercising your rights as a tenant.
That just seems so unfair.
Exactly. Retaliatory eviction is illegal in California.
Okay.
And it happens more often than you might think.
And let's not forget the impact of recent events like the COVID-19 pandemic.
Right.
There are still certain protections in place for tenants who've been affected by that.
Absolutely. This highlights how important it is to stay updated
Right.
on the evolving legal landscape. In fact, a new law assembly bill, 2347, is set to change the eviction process in January 2025.
So even if you think you know the basics, things can change.
Exactly.
And staying informed is key.
Precisely. It's a dynamic legal landscape, and having access to the most up-to-date information can be a real game changer.
Okay, let's dive into a scenario I think that's on a lot of renters' minds.
Okay.
Wrongful eviction.
Yeah.
What does that actually mean?
Right.
And what are the potential consequences for landlords who engage in these practices?
Wrongful eviction occurs when a landlord forces a tenant out illegally.
Okay.
And it can manifest in many ways.
Yeah.
For example, one of our sources highlights the devastating impact of being forced out due to truly unlivable conditions.
Okay.
Like rampant mold,
sewage
issues, or even dangerous structural problems.
So even if there's no formal eviction notice,
right,
if a landlord is creating an environment that's basically forcing me out, that could be considered wrongful eviction.
Absolutely.
Okay.
It's about understanding the broader context of what constitutes illegal eviction practices.
Yeah.
And it's not just about those extreme cases of uninhabitable conditions.
Yeah.
What if you're dealing with persistent harassment from the landlord or even neighbors?
Yeah. So if the landlord is not addressing a situation, that's making my home unsafe.
Right.
Or unlivable.
That's right. It's about that fundamental right to quiet enjoyment of your home. And let's not forget those situations where landlords try to pull a fast one, like falsely claiming they need the unit for themselves.
Yeah.
You know, that classic owner move-in eviction,
right,
just to get around rent control or raise the rent.
Those stories always make my blood boil.
I know.
But it sounds like there are some serious consequences for landlords who engage in those sorts of tactics.
You bet. Our sources mention something pretty eye-opening.
Okay.
Triple damages in cases of bad faith.
Wait, triple damage?
Triple damages.
So if a landlord is caught wrongfully evicting a tenant just to get a higher rent, they could be hit with a major financial penalty.
It can be a significant deterrent.
And here's another important point that I noticed.
Yeah.
It's not just the landlord themselves who can be held liable. Agents and property managers can also be on the hook.
That's right. This underscores the need for everyone involved in the rental process to be well-versed in tenant rights and legal obligations.
This is really starting to paint a picture of how much local laws matter.
Yeah.
Can we zero in on some specific city examples?
Absolutely.
To see how these principles play out in different contexts.
Let's take a closer look at Beverly Hills and Los Angeles.
Okay.
Two cities with unique ordinances that can impact tenant rights.
Okay, so what jumps out at you from our source material about these two cities?
Well, what's fascinating here is that both Beverly Hills and Los Angeles have provisions for triple damages in cases of bad faith evictions.
Wow, so they're really sending a strong message.
It seems like they are.
Yeah, that these practices won't be tolerated.
Yeah.
But I imagine there are some nuances between how these two cities approach tenant protections.
Definitely. Yeah. And that's why having local expertise is so critical. Okay. For instance, in Beverly Hills, not only the landlord, but any agent acting on their behalf.
So that means real estate agents?
Yes.
Or property managers involved in the process could also face consequences.
Exactly. And in cases of fraudulent owner or relative move-in evictions, the penalties can be particularly steep.
Yeah.
We're talking triple the amount of rent the tenant would have paid.
Wow.
For up to 6 months.
That's a serious chunk of change.
It is.
Makes you wonder how often landlords actually get hit with these penalties.
That's a great question.
Right.
And it highlights how important it is to have access to data and legal expertise to understand the real-world application of these laws.
Okay.
But let's move on to Los Angeles.
Okay.
What stands out to you about their approach?
Well, from what I'm seeing in our sources, it looks like Los Angeles also holds landlords and their agents accountable for wrongful evictions. They also have provisions for triple damages in those bad faith cases.
Yes.
But what really catches my eye is that tenants in Los Angeles may actually be able to recover their attorney fees.
Oh, that's huge.
If they win a wrongful eviction case.
That's a crucial distinction. Knowing that you could potentially recoup those legal expenses can be a game changer for tenants who might otherwise hesitate to pursue their rights.
It definitely feels like it levels the playing field.
You're right.
Which is so important when you're talking about a system that can sometimes feel stacked against tenants.
You're right. And that's precisely why having a deep understanding of your rights and options is so crucial in navigating these potentially tricky situations.
I'm already feeling more informed just from this initial discussion.
I'm glad.
And I'm eager to delve even deeper into this topic.
Me too.
But for now, let's pause here.
Okay.
And give our listeners a moment to process all of this valuable information.
Sounds good.
We'll be back with part 2 of our deep dive into California eviction laws in just a moment.
All right.
Stay tuned.
Welcome back to our deep dive into the world of California eviction laws. We've covered a lot of ground already, but there's so much more to uncover when it comes to protecting your rights as a tenant.
I'm ready to keep digging. We've talked about what constitutes a wrongful eviction, those red flags, and even touched on some city-specific ordinances. But I'm curious, are there other examples of wrongful eviction that we haven't discussed yet? You bet. Remember, it's all about a landlord using tactics to force you out illegally. Our sources mention some scenarios that might surprise you. Let's say your landlord decides to illegally shut off your utilities, like electricity or water, or even go so far as to change the locks locking you out of your own home.
Oh, wow.
That's a textbook example of wrongful eviction, even without a formal notice.
So even if it doesn't follow the typical eviction process, if the landlord's actions essentially make the place unlivable, that's still a violation.
Exactly. It's about recognizing those bad faith actions that force a tenant out. Another example that might resonate with folks in rent-controlled units is if a landlord repeatedly tells a tenant to vacate, even without a valid reason. It creates this hostile environment, pressuring them to leave. It's like a slow-burn eviction tactic designed to wear you down emotionally. Makes you wonder, what about situations where the landlord just ignores a problem tenant who's disrupting everyone else? Could that also be considered a form of wrongful eviction?
Absolutely. If a landlord consistently ignores complaints about a neighbor who's creating a truly disruptive or unsafe environment, loud parties every night, threats, or even property damage, and that's impacting your peaceful enjoyment of your home, it could be grounds for taking legal action.
It's fascinating how many different scenarios can fall under wrongful eviction. It seems like it's not just about the physical space, but also that sense of security and well-being in your own home.
You hit the nail on the head. It's about having that fundamental right to live in peace and safety. And our sources highlight some pretty sneaky tactics that some landlords try to pull, like pretending to move into a tenant-occupied unit, especially those rent-controlled ones, just to get a tenant out.
It's amazing how creative some landlords get when they're trying to skirt the law. But it sounds like the law is catching up to those tactics, right?
Definitely. The courts are becoming increasingly savvy about recognizing those bad faith attempts to circumvent tenant protections. Another example is when a landlord tries to demolish a rent-controlled unit without proper permits.
Oh, wow.
It's a clear violation, and tenants have recourse in those situations.
It's good to know that there are consequences for those landlords who try to play fast and loose with the rules. But let's be fair, not every landlord is a villain in a horror movie.
Right.
There are legitimate reasons for evictions, right?
Of course. There are absolutely situations where a landlord has a legal right to evict a tenant, and it's important to understand those as well. For instance, if a tenant isn't paying rent or repeatedly violates the terms of their lease agreement, those are valid grounds for eviction.
So it's all about finding that balance, right? Protecting tenants' rights while also acknowledging landlords' legitimate interests.
Precisely. It's a delicate balance, and that's why having clear laws and regulations is so essential. And speaking of regulations, remember that new law we mentioned earlier, AB 2347? It's going to shake things up a bit when it comes to the eviction process in California starting in January 2025.
Yeah, we briefly touched on that in part 1.
Right.
But I think it deserves a deeper dive, especially since our listeners will be dealing with those changes soon.
Yeah, for sure.
Can you break down some key provisions? What should tenants be aware of?
Absolutely. One of the most significant changes is the expansion of just cause eviction protections. This means landlords will need a solid reason to evict a tenant in most cases, like non-payment of rent or lease violations. No more evicting someone just because they want to.
So it's adding another layer of protection for tenants, making it harder for landlords to evict without a legitimate reason.
Exactly. It's about increasing security and stability for renters.
Yeah.
Another big change is the increased protection for tenants struggling to make rent.
Okay.
AB 2347 will require landlords to offer a repayment plan in certain cases before even filing an eviction lawsuit.
Oh, wow.
This gives tenants more time and breathing room to catch up on rent and avoid being displaced.
That sounds like a real game changer for tenants facing financial hardship. Are there other aspects of this new law that we should highlight?
There's one more I think is worth mentioning. The new law tackles the issue of serial filers, which are landlords who have a history of filing eviction lawsuits, even if those cases end up getting dismissed.
Hold on. Landlords actually do that. File multiple lawsuits against the same tenant, even if they don't have a valid reason.
It happens more often than you might think. Sometimes it's a tactic to harass tenants, trying to pressure them to move out, even if they have a legal right to stay. AB 2347 aims to curb this practice by creating additional hurdles for landlords who have a pattern of these serial filings.
It sounds like this new law is really making strides in leveling the playing field between landlords and tenants. It's giving tenants more tools and protections to stand up for their rights.
That's the goal. It's about ensuring fairness and promoting a more balanced dynamic in the rental housing market.
Okay. I think we've covered the major changes coming with AB 2347. But let's shift gears a bit and talk about damages. What kind of compensation can tenants actually receive if they've been wrongfully evicted? What does that look like in real terms?
Great question. Our sources highlight 3 key areas of potential damages: lost rental value, moving costs, and emotional distress.
Let's unpack each of those. What does lost rental value actually mean in this context?
It refers to the financial loss a tenant experiences when they're forced out of a unit that was below market rate. Think about it. If you're in a rent-controlled apartment and suddenly have to pay a much higher rent for a comparable place, you've incurred a real financial loss. The courts take that into account when calculating damages.
So it's not just about getting back the rent you already paid, but also accounting for that difference in rental costs over time.
Exactly. The courts consider the length of time you were displaced and the difference between your previous rent and the fair market value of a similar unit.
And remember, those triple damages we discussed earlier.
Yeah.
Those can really amplify the financial consequences for landlords who engage in bad faith evictions.
That's right. It can make a real dent in their profits, which hopefully acts as a strong deterrent. But let's not forget about those moving costs. It's not just about finding a new place, it's all the expenses associated with that move.
Yeah, moving is never fun or cheap. What kind of expenses typically fall under moving costs in these cases?
We're talking about the practical stuff, packing transportation, hiring movers if needed, but it also includes those often overlooked expenses like application fees, security deposits for the new place, and even things like changing your address and utilities.
It's interesting how these damages are really designed to cover both the tangible and intangible costs of wrongful eviction.
And speaking of the intangible, let's talk about emotional distress. How does that factor into the equation? Well, it's important to acknowledge that wrongful eviction can be incredibly traumatic. Imagine being forced out of your home, facing uncertainty, and feeling like your sense of security has been violated. It can lead to anxiety, stress, sleeplessness, even depression.
It's like having the rug pulled out from under you. Your entire world is disrupted and that emotional toll is real.
Exactly. And the law recognizes that those emotional harms are just as valid as the financial ones.
It's fascinating how the legal system attempts to quantify those intangible experiences. I imagine proving emotional distress can be a bit tricky though, right?
You're right. It often requires documentation, testimony, even expert opinions to demonstrate the impact of the wrongful eviction on a tenant's mental and emotional well-being. But the key takeaway is that the law acknowledges and seeks to compensate for those harms.
This is all so insightful. We've covered a lot of ground, but there's still some areas I'd like to explore further. Are we ready for part 3 of our deep dive?
Bring it on. We're just getting started.
Welcome back to the final part of our deep dive into California eviction laws.
Yeah.
I feel like we've been on this whirlwind tour of tenant rights and wrongful evictions, and even gotten a sneak peek at those upcoming legal changes.
It's been a journey.
But there's one more area I want to explore before we wrap things up.
Okay, shoot.
We've talked about the different types of damages tenants can receive if they're wrongfully evicted.
Right.
But I'm curious about the nitty-gritty.
Okay.
How are those damages actually calculated?
Yeah.
What are the factors that determine how much compensation a tenant can actually get?
It's a great question, and it gets to the heart of how the legal system tries to right those wrongs. As we discussed earlier, lost rental value is a major component of those damage calculations.
Okay.
It's all about determining that financial hit a tenant takes when they're forced out of a unit that was below market rate.
So let's say you're living in a rent-controlled apartment.
Yeah.
That's a steal compared to similar places in your neighborhood.
Yeah.
You're wrongfully evicted, and now you have to pay a much higher rent just to stay in the same area.
Yep.
How do the courts actually calculate that lost rental value?
It's not as simple as just looking at the difference between your old rent and the current market rate.
Okay.
The courts consider the length of time you were displaced.
Okay.
So if you were forced out for 6 months
Yeah.
and you had to pay an extra $500 a month in rent, that adds up to a significant financial loss.
That's a lot of money.
Yeah. So the longer you're displaced and the bigger that gap between your old rent and the current market rate, the higher the potential damages.
And don't forget about those triple damages.
Oh, yeah.
We talked about those in those bad faith cases.
That can really amplify the financial consequences for landlords who try to pull a fast one.
Yeah. It's definitely a good thing
Yes.
for tenants.
Big time.
But let's pivot back to those city-specific ordinances.
Okay.
We touched on Beverly Hills and Los Angeles earlier.
Yes.
I'm wondering if we can unpack those examples a bit more. Really highlight what makes each city's approach unique.
Excellent point. Local ordinances add another layer of complexity.
Right?
And it's crucial for tenants to understand the specific laws in their city. So let's start with Beverly Hills. One thing that stands out is that not just the landlord, but anyone acting as their agent
Okay.
can be held liable for wrongful eviction.
So that means if a real estate agent or a property manager is involved in the process
Yes.
and they're knowingly participating in a wrongful eviction, they could face legal consequences as well.
That's right. It broadens the scope of accountability.
Wow.
And in those fraudulent owner or relative move-in evictions, the penalties are especially steep. We're talking about triple the amount of rent the tenant would have paid for up to 6 months.
That's a serious financial hit.
It is.
It definitely sends a message that Beverly Hills is serious about protecting its tenants.
For sure.
Now, what about Los Angeles? What are some key things that set their approach apart?
Los Angeles also holds landlords and their agents accountable for wrongful evictions.
Okay.
And like Beverly Hills, they have provisions for triple damages in cases of bad faith. But one thing that's particularly tenant-friendly in Los Angeles is the potential for tenants to recover their attorney fees if they win a wrongful eviction case.
That's huge.
That's a game changer.
Yeah, knowing that you could potentially get reimbursed for those legal expenses makes seeking legal help much less daunting.
Exactly. It removes a significant barrier for tenants who might otherwise hesitate to fight for their rights.
Yeah, these city-specific examples really drive home the point that local expertise is essential.
Couldn't agree more that local knowledge can be the difference between a successful outcome and a frustrating legal battle.
This deep dive has been a real eye-opener. I feel like we've explored so many facets of tenant rights and eviction laws, from the basics to those subtle nuances that can make all the difference.
Yeah, we've covered a lot.
Before we wrap things up, is there any final piece of advice you'd like to leave our listeners with?
I think the most important takeaway is that knowledge is power. The more you understand about your rights as a tenant, the better equipped you'll be to protect yourself and navigate these complex situations. Don't be afraid to seek legal counsel if you believe your rights have been violated.
Right.
There are resources available to help you, and you don't have to go through this alone.
That's such an empowering message.
I hope so.
It's a reminder that we're not just passive players in this system.
Right.
We have rights.
We do.
And we have options.
Absolutely. Being informed is the first step toward taking control of your housing situation and ensuring you're treated fairly.
Well, on that note, I think it's time to wrap up our deep dive into California eviction laws. We've covered so much ground, from understanding your basic rights as a tenant to navigating the complexities of wrongful evictions and exploring those crucial city-specific ordinances.
It's been quite a journey.
I hope our listeners are walking away from this conversation feeling more informed, empowered, and ready to advocate for themselves.
Me too. Remember, this is just the beginning of your journey as an informed and empowered renter. Stay curious, keep learning, and don't hesitate to reach out for help when you need it.
Until next time, stay informed, stay engaged, and know your rights.
Call now 714-442-9741. Thank you.